Lordship, I beg to mention one criminal petition.
Hmm.
There is urgency in the matter since the petitioner has been called by the town police for attendance tomorrow. So, can this matter be heard in second half?
Criminal petition.
Yes.
What do you want?
I want the direction for this giving the statement by this online virtual mode.
Hmm?
Virtual mode statement may be allowed to give given virtually.
You don't know. There
There is a provision as per the UNSS. When this
is
my lord, I wish to mention item number 24.
Hmm.
I am for the applicant on behalf of senior advocate D. Majinder.
Hmm.
However, it has been informed to us that the learned advocate for amicus that learned
on the prayer of Mr. Your name, please.
Pitaka.
Appearing on behalf of Mr. D. Majinder, learned senior counsel to the applicant. This matter after
My lord, matter may be fixed on 14th of this month.
based on 14/05/2026. Huh? Yes.
May I Lordship, I beg to mention item number 13 on behalf of N. Sharma, with the consent of other parties.
Mr. So-and-so. Mr. Vincent, the council said the list is better after 3 weeks.
Lordship, 2 weeks. Yes.
May Lordship. Lordship, I beg to mention unlisted item.
Huh?
I beg to mention unlisted item on behalf of conducting counsel Anjan S. Sahu Prasad.
Hmm.
Your Honor, the matter was supposed to be listed today. However, due to the typographical mistake, matter could not be listed today.
What is the urgency? What is the matter about?
Your Honor, this is a bail application for just tomorrow.
When is supposed to be listed?
Today it's Your Honor. Your Lordship.
What is the last order?
Last order, this court has pronounced on this court last heard on 6, and this court has pronounced in open court the matter to be listed after 1 week. That is today.
6.
Yes, last heard on 6.
Tomorrow.
Fair Lordship. Lordship, I beg to mention item number 16 on behalf of M. Kato, Lordship. This matter may be listed on 12th May, Lordship.
On the prayer of MS So-and-so, learned counsel for learned counsel appearing on behalf of Mr. M. Kato. Learned counsel for the petition. This matter listed on
12th May, Lordship. Obliged, Lordship.
05.
Item number 1.
May I please, my lord? My lord, here I am challenging, there is a caveat, my lord, there may be discharge on him.
Craving for the caveat, Lordship. My caveat may be discharged, Lordship.
Caveat. Not listed. Here, learned counsel for the caveat is 10 church. Yes.
May I please, my lord? My lord, here I am challenging the impugn order dated 13/3/2026. But, my lord,
Page.
Lordship will find the page at, my lord, 138 is the, my lord.
138. Yes.
138 here.
136. 136.
136, my lord. 136 is the, my lord, appeal, my lord, against judgment passed by, my lord, first appellate court, my lord, And along with this appeal, my lord, a missed case was also filed for seeking stay of the my lord. Order passed by the my lord. Huh? Second Keba decision, my lord. At page 138, my lord. By the my lord, civil judge.
136 is admitting
Admit
138 is staying the other.
order, my lord. By the my lord, civil judge senior division, my lord. My lord, here my against the my lord order, my lord, of my lord 21/2/2026, my lord. My lord, the petitioner has
What is that order?
my lord,
What do we call it?
Madam.
Appellate, what is this? Customary?
court, my lord.
What it is?
Lord, you will find. Well, initially, my lord, first Keba decision is my lord that page 82, my lord.
Yes.
Page 82 is the first Keba decision, my lord. Type copy is at my lord. 89, my lord.
Okay.
This is the first Keba decision, my lord. Whereby, my lord, at page 90, my lord, the operative part, my lord. The part of my lord, may I read, my lord, paragraph 5, page 90, my lord. After hearing all the facts, Keba decision stated that late Muto Basar sold land shall not be claimed. It has been about 47 years. No complaint was made during the said period. Sri Bomli Basar, the present matter, the petitioner, shall not claim his grandfathers did not sold entire land and also not claim that late Minsa Bagra being married to Nepali Chetri have no right to purchase land. The land purchased by late Minsa Bagra belongs to Sri Minjum Bagra. As per claim of the Bomli Basar that entire land was not sold by his father, a small portion of land shall be given to Sri Bomli Basar, my lord. Against this, my lord, order of the village level,
Entire land.
my lord,
Small person.
a small portion, my lord, was given to me, my lord.
Yeah.
Against that, my lord, I preferred an appeal, my lord, before the, my lord, lordship will find at page 91, my lord. Before the president, my lord, intervlace customary court, my lord. This is my appeal, my lord. And my lord,
This is
my lord, before that, my lord, the respondent has also preferred an appeal, my lord. Lordship will find at page 93, my lord.
93.
My lord. My lord, kindly see, my lord, the cause title of the appeal, my lord, for a moment, my lord.
This is by respondent.
Respondent, my lord.
Okay.
My lord, an appeal under section 3, Roman 3(4) of Arunachal Pradesh Civil Courts Amendment Act.
You also they filed an appeal.
Yes, my lord.
Page 91.
Yes, I am also agreed by the Keba decision, part of the my lord, and he is also agreed by the Keba decision, my lord, and he has filed the appeal, my lord. Though it is mentioned that section 3, Roman 3, within bracket 4, my lord, it should be, my lord, an appeal under section 15, clause 4 of the my lord, subclause 4 of the my lord, subsection 4 of the Arunachal Civil Court Act, Amendment 2022, my lord. My lord, this is basically, my lord, we have both filed the first appeal before the my lord, Interlace, my lord, Territorial Customary Court, my lord. Against this judgment, my lord, they filed and my lord, again they filed and my lord, appeal before the my lord, the ADC, my lord, additional district judge, my lord, which was, my lord, withdrawn, my lord, dismissed on withdrawn, my lord. Thereafter, they have preferred, my lord, the present, my lord, again, my lord, first appeal before the my lord, the senior civil judge, senior division, my lord. My lord, lordship will kindly see, my lord. The order, my lord, has already seen, my lord. Whereby, my lord, the judgment rendered by the my lord, Interplace Territorial Council has been, my lord, stayed, my lord. My submission is that, my lord, after the decision rendered by the my lord in a appeal, my lord, by the my lord, my lord, Blaze Territorial Customary Court, my lord, that is apex court.
Page 123. Page 123,
My lord.
revision.
My lord, page 123 is there, my lord. My lord, there are two, my lord, appeals, my lord, one by us and one by the respondent, my lord. And they have approached this honorable court for clubbing of those two appeals, my lord. And accordingly, my lord, those two appeals were clubbed together, my lord. And by a common judgment, my lord, the appeal was disposed of, my lord.
Club both the appeals.
My
Yes.
lord.
Ah.
Page 1, second kaba, my lord, page 130, my lord. Eight, my lord, page 133, my lord. This is the translated copy, my lord.
What does it say?
It says, my lord, at page 134, my lord,
Half acre only to let.
that as per the documents laid Muto Bazar on dated 10/2/1992, 82, sold land measuring half acre of land to Minsa Bagra. The entire land was not sold, and therefore, while observing the claim of Sri Bomli Bazar being legal, correct, out of the total area of the land, half acre of the land shall be given to Minjum Bagra, and entire rest of the land belongs to the Sri Bomli Bazar as held in the Keba decision, my lord. My lord, by this order, my lord, what has been found, my lord, half acre of the land, which was admittedly, my lord, purchased by Srimati Minsa Bagra, which was further transferred to Minjum Bagra, who is the brother of the late Minsa Bagra, was given in favor of the, my lord, the respondent, my lord. And the rest of the land, my lord, in favor of me, my lord. Against this, my lord, order, my lord, again they have filed an appeal, my lord. Appeal, my lord, under, my lord, Lordship will find at page 136, my lord, admitting the order of the appeal, my lord. The appeal has been filed under section 15(4), my lord, again, my lord. The present appeal is filed invoking provision under section 14(4), my lord, of the Arunachal Pradesh Civil Code Amendment Act 2022, read with section 96 and order 41 rules of CPC against the impugned Keba decision dated 21/2/2020 passed by the Blaze Authority Customary Court of Inter-Blaze Territorial Council, Basar, my lord. My submission is that, my lord, admittedly, my lord, they filed, my lord, first appeal and the same provision of law 15(4), my lord, of the, my lord, Arunachal Pradesh, my lord, Civil Code Amendment Act, my lord, before the, my lord, Inter-Blaze, my lord, Inter-Blaze Territorial Council, my lord. After disposal of this by the, my lord, Inter-Blaze Territorial Council, my lord, they have again filed appeal before the, my lord, Civil Judge Senior Division under same provisions of the law, my lord. My respectful submission is, my lord, there cannot be two first appeals, my lord. At best, my lord, they can file a, my lord, second appeal under section 100 of the CPC, though with a limited condition, my lord, read with, my lord, section 101 of the CPC, my lord. That too, my lord, the second appeal can be entertained by the only, my lord, this Honorable High Court, my lord. My lord, may I place all the relevant provisions, my lord, of the, my lord, why I have CPC, my lord, they have filed again this, my lord, under section 96, read with, my lord, order 41, my lord. First, my lord, may I come to section 96, my lord? Huh? Oh. Pani- डेट में कुछ लिख के रखो My lord, first, my lord, may I read the section, my lord, 96 of the CPC, my lord. May I read, my lord?
Please, please.
Save where otherwise expressly provided in the body of this code or by any other law for time being enforced, an appeal shall lie from every degree passed by any court exercising original jurisdiction to the court authorized to hear appeals from the decision of the such court, my lord. In my case, my lord, the first original decision was rendered by civil court, that is by the, my lord, Blaze Authority, my lord, Keva, my lord,
Yes.
Keva. Against that, my lord, they have chosen, my lord, section 15(4) by filing an appeal before the, my lord, Interblaze Territorial Council, my lord.
Where is section 15(4)?
My lord will find at page, my lord.
Amended.
Yes, my lord. I have annexed the, my lord, all the acts, my lord. My lord will find at page, my lord, 46 at page 47, my lord. Earlier, my lord, pre-amended, my lord, Act of 2021 and in the Civil Court Act matter of Arunachal Pradesh, appeal can be filed against the Keba decision before the, my lord, the district judge or before the additional district judge, my lord. By this amendment, my lord, some modifications were done, my lord. Lords, you will find at page 147, my lord. 4, my lord, 15(4), my lord. An appeal, may I read, my lord? An appeal from Blaze Authority, if agreed, my lord, has been, my lord, deleted by an, my lord, amendment made in, my lord, AFR, my lord, by section 13, my lord. The if agreed to parties shall lie before the Interblaze Territorial Council or Apex Customary Court, whatever name called, which shall settle the case as per the local traditional customary law under the provisions of section 40 of the Assam Frontier Regulation of Justice, 1945, my lord. Now, my lord, there is another proviso, my lord. Provided that an appeal against the order of Interblaze Territorial Court or Apex Court, Customary Court, shall lie before the courts of Civil Judge Senior Division, the courts of Civil Judge Senior Division, the courts of Additional District Judge, or the courts of District Judge, as the case may be, as per their territorial and the pecuniary jurisdiction, my lord. My lord, this provision will come into effect, my lord, when the, my lord, the Interblaze, my lord, Territorial Council passes and, my lord, decree in the capacity of original jurisdiction, my lord. Then, my lord, this proviso will applicable, my lord, will apply, my lord. Because, my lord, section 36 of the, my lord, AFR says, my lord, the Blaze Authority, my lord, the first instance of the, my lord, the civil, my lord, justice shall be administered by, my lord, under, my lord, section 36 of the regulation, my lord, by the Blaze Authority, my lord. And, my lord, the Blaze Authority is also being defined in the amended, my lord, AFR, my lord, whereby, my lord, kindly see page 150, my lord, the amended AFR, my lord.
Of what?
My petition, my petition, my lord. I have annexed the amended AFR, my lord. The Blaze Authority has been defined, my lord. Section, my lord. It is also, my lord, available in, my lord, volume 1, my lord. By, my lord, section 3, Roman 4, my lord. May I read, my lord? After clause E, the following clause shall be added, namely F, my lord. The F has been inserted, my lord. Blaze Authority means of traditional village council or inter-village territorial council or apex council by whatever name called, including the head Gaubura, Gaubura, and traditional village head, my lord. My lord, this has to be read with, my lord, section 36 of the, my lord, AFR, my lord. Section 36 is the, my lord, the first instance of the, my lord, civil court, my lord, under the, my lord, AFR, my lord. May I read, my lord, section 36, my lord? Civil justice shall be administered by the Blaze Authority, my lord. So Blaze Authority includes, my lord, Inter-Blaze, my lord, Blaze Territorial Council, my lord. So, my lord, my respectful submission is that, my lord, the Inter-Blaze, my lord, Territorial Council, my lord, have two jurisdiction, my lord. Original jurisdiction in terms of section 36, as well as, my lord, appellate jurisdiction in terms of section 15(4) of the, my lord, Arunachal Pradesh Civil Code Amendment Act, my lord.
But provider provides that 54.
Yes, my lord, this proviso will come into effect, my lord, when the Inter-Blaze, my Territorial Council, my lord.
Let us read again. This
Which one, my lord?
15(4).
15(4), my lord.
An appeal from village authority.
Yes, my lord.
So like for village territorial customers court by whatever name called. We shall settle the case as per the local juris customary one from section 14. Provided an appeal against the order of the inter-village territorial court.
FS shall lie before the court of civil judge, junior division, my lord, in the civil courts, my lord, in accordance with the, my lord, pecuniary and territorial jurisdiction, my lord.
Ah,
My submission is that, my lord, this proviso will come, my lord, will apply when the, my lord, inter-territorial village council, my lord, exercise its, my lord, original jurisdiction, my lord. Against that, my lord, order, this proviso will apply, my lord. Otherwise, my lord, this is my humble submission, my lord. My lord may take a call, my lord. Because, my lord, the first instance is that, my lord, the appeal shall lie from Blaze Authority to, my lord, the Inter-Blaze Territorial Customary Court, my lord, or apex court, my lord. It is clear, my lord. It's a mandatory, my lord, appellate provision, my lord. Stated provision, my lord. So second proviso will come into effect, as I said, my lord. The Blaze, well, the first instance of the, my lord, civil court is under section 36 of the AFR. By an amendment in the AFR Amendment Act, my lord, a section F has been, my lord, clause F has been inserted, my lord, whereby, my lord, Blaze Authority includes, my lord, the Territorial Village Council, my lord. So, my lord, the Inter-Territorial Village Council has two jurisdictions, my lord. Original as well as appellate jurisdiction, my lord.
And why they have not clarified here?
Yes, that's why, my lord.
They have not clarified.
That's why, my lord, my submission will be that, my lord. That's why, my lord, as my lord, CPC is applicable, my lord, under the Act of, my lord, Civil Code Act, my lord. So, my lord, we have to read section, my lord, 100, my lord. So, section 100 says, my lord, as section 96 says, my lord, the first appeal will lie from the original decree of the first court, my lord, first instance court, my lord. So, my lord, the second appeal, my lord, second may read, my lord, the provision of second appeal, my lord, save otherwise expressly provided in the body
No,
of
I've
this.
understood that. According to you,
Yes, my lord.
this what is called Inter-Village Territorial Court or apex customary court
Yes, my lord.
has two jurisdictions.
Two jurisdictions.
One is original, other one is appellate.
Appellate, my lord.
An appeal will lie.
Yes.
Appeal will lie under this section 15(4) if the customary, I mean, apex customary court decides a matter
Yes,
in
my
its original jurisdiction.
original jurisdiction.
If it is on appellate jurisdiction,
Then in the
then no appeal will lie before the civil court.
yes,
But why they have not clarified this?
yes, my lord.
They
So-
said provide an appeal shall against the order of the judge shall lie before the court of civil judge so and so. Should have clarified it,
Yes, ma'am.
saying that the appellate and this thing. Because both are village authorities
Both are village authorities.
and they have to decide as per the local customary.
Yes.
So I think the idea behind it, I mean, the intention of the legislation is to provide this these both these fora, village authorities, providing an sufficient opportunity to decide as per the custom.
Yes, ma'am.
Suppose if you file go beyond that, comes to the regular court, it should be decided as per the law, not exactly on the customary thing.
As a de novo, my lord. In the regular courts also, it will be, my lord, tried as a de novo, my lord. And so we have to read these things with the, my lord, section 100, my lord.
Will here? Huh?
My lord.
Will here, we cannot decide today.
Yes, my lord.
Although
There's-
he has filed a caveat.
my lord, that's why, my lord,
Next,
this has to be, my lord, settled, my
Huh?
lord. This has to be settled, my lord. My lord, if my lord is not, my lord, staying the, my lord, order passed by the, my lord, learned, my lord, civil judge senior division, my lord, status quo should be maintained, my lord, in respect of
Yes,
the,
maintain the status quo, will deliver it also.
yes, my lord, this has to be resolved, my lord. No.
No, if we have to decide it, if pending return, we can keep it, we will suspend the product proceeding.
Yes, yes, my
When
lord.
is the next?
24th, my lord.
24. Coming Friday, Lordship, this month.
Suspend it.
Yeah.
Because it's a, I mean, because today we cannot decide. Even if we heard it also.
This has to be resolved, my lord.
If my Lordship may allow me to make my
Yes.
submission, Lordship.
But it says
Up to
tomorrow,
me.
I have not taken.
May I please, Lordship?
In fact, today it's not possible to conclude, I mean, they decide the matter.
Yes, Lordship. Lordship, my Lordship has rightly pointed out the Act, Arunachal Pradesh Civil Court Act. Lordship, there are two procedures where the civil case to be initiated. Initially, it was AFR, Lordship, of course, the Section 40, which has given the unlimited power to the blaze authorities. And then again, it was Section 46, where the affiliate power was given to the Deputy Commissioner and ADC, though it has been amended, Lordship. Now, Lordship, when we initiated a proceeding under civil court, CPC, it is clear, Lordship, under Section 9, all civil suits to be filed. And then next, Section 96, first appeal, and then Section 100, this is second appeal, subject to the limitation of this 101, Lordship. Now, Lordship, then the Arunachal Pradesh Civil Court Act 2021 was brought in, Act was enacted. Now, the power and functions of all civil courts and the blaze authorities has been recognized as a customary court. But Lordship, what happened? Under Section 15, appeal, the provisions of appeal has been provided. But the legislature, they omitted the appeal against the blaze authorities. Now, immediately, they brought in this 2022 amendment, as my Lordship has seen just before, where it is the Act, it is very clear, Lordship. The first blaze authorities, the decision against the blaze authorities has to appeal to be before the interblaze. Then from the decision of interblaze, it has to be filed before the civil court of junior division, senior division, additional district judge, and district judge. And only limitation provided under civil judge junior division, the pecuniary limitation up to 10 lakhs only. That effort, Lordship, all three courts, senior division, additional district judge has been provided unlimited. And even, Lordship, they have been given the status of original court also. They can try the original suit
But
also.
it runs counter to the CPC.
Lordship, now,
You cannot enact a law. I mean, it's a procedural law.
yes, Lordship, but this is a special act, Lordship. And the language provided under the act is very clear, Lordship.
That's why I will have to, today we cannot enter into this portion. So
Yes, Lordship.
we'll hear you.
But if the staying of the provisions, proceedings, Lordship, that is affecting my right also because,
There cannot be two appeals. You may be correct while literally reading the Civil Courts Act.
yes, Lordship, yes,
That there is a provision of two appeals.
yes,
Number one, appeal lies against the village authority to the apex customer.
yes,
Number two, they have provided by proviso,
yes,
said the appeal against this so and so will be before the civil judge. I think it's runs counter to the civil, the CPC.
yes. Now then, 96,
Prima facie.
yes, 96,
Therefore, we'll hear you. It requires a detailed hearing because you will have to settle it. It's not it.
the problem, Lordship, if my
Just
Lordship,
maintain, we'll direct them not to proceed with the thing. We will stay the further proceedings. Why not sitting aside today? Obviously, and to you maintain, so far as the status of land is concerned, you maintain the status. This two line will pass today.
status regarding Lordship, I
And
make
any
it,
that you fix it, we'll hear it.
I make a small summation regarding the status, Lordship.
Ah.
Lordship, what happened? The impugn affiliate cover decision was passed on 21 February. Just after impugn order, he entered into the disputed land.
We'll make it clear. Don't touch, nobody.
Status quo
no
prior,
party should touch the land.
status quo prior,
Till the matter is settled.
status quo prior to impugn affiliate cover decision. That would be suffice, Lordship.
Again, you'll there's a
Lordship, because I have already obtained injunction order against him also. Because
where
I have,
I staying there.
yes, that's why, Lordship, I am saying. If my Lordship is staying the proceeding,
Ah.
then they will take undue advantage. They will again enter into the
So we'll make
disputed
it
land.
clear.
My lord will make it clear, my lord.
Status quo prior to affiliate.
Status quo adjourned today includes, will clarify that no one should do anything
Yes.
with the land.
Mm.
All right. Because you said he has already entered.
Yes, after the impugn cover decision, since that has been,
You are
that has been
there.
stayed.
Don't enter.
Yes.
That is the demand.
Yes.
What is the nature of the land?
Jum landlords.
Is it some kind of garden or some?
No.
Just a,
Just Jum land, but nearby the blazes. So he has recently constructed local hut, carried out art cutting work. That has been stayed.
you keep it.
Yeah.
Because tomorrow again,
Till we
the
decide.
the proceeding.
Because we don't know the outcome. All right. Heard Mr. R.C. Carson for the petitioner. This revision petition is directed against the order dated 13/03/2026 passed by the learned civil judge within bracket senior division, Quashing, senior division, Alo. In civil appeal number 04 of 2026 and miscellaneous case number 18 of 2026, whereby the appeal filed by the respondent, sole respondent, respondent under section 15 within bracket 4 bracket clause of the Arunachal Pradesh Civil Courts Act 2021
Amendment Act
Amendment
2022. Lord.
and amended in 2022, reduced section 96 and order 41, rule 1 CPC 1908, against the whereby the learned civil judge senior division has admitted the appeal and also suspended the Keba decision that is
Blaze तो इंटरब्लेस का कौन सा होता है? 130 पेज कितना है? Date 21
report that against the impugn cover decision.
Page 130 में है.
Page 136.
Wait.
issue notice returning by 4 weeks. 3 weeks.
Lordship, since this is the question here is only law when, so may I humbly pray that if the proceedings stayed, then can it be on coming Thursday? Because affidavit need not be required here, only to decide law when.
Next Thursday.
Yes,
If you
Next week.
coming.
Yeah,
Aniola, as Tuesday na.
well, next week.
Coming
week.
coming Thursday,
Ah.
Lordship. Today is Tuesday, Lordship.
Let me on next
10 days.
10 days.
Returning by 10 days.
10 days.
Huh? Next paragraph.
Asking.
Is
21st.
Mr. K. London Council enters agreement. They have
29.
sole response. No, no, the issuance of proper notice is dispensed with. You have the copy, or you have already.
Yeah, I have received.
Okay. Next. Having considered that the no the Kaba decision that it 2106. No, the impure order.
Bisa dito ko. 29
Against the Kaba decision dated 21/02/2026 was binding.
Twitter from 0.
What is called Apex Customary Court?
Intervillage Territorial Customary Court.
Intervillage Customary
Territorial Customary Court.
Court of Passer has been appears the primacy appears to be on a
Circle.
second appeal in terms of the in terms of section 15(4) of Arunachal Pradesh Civil Courts Act 2021, read with section 96,
29 ka apna ho.
and also considering the provisions of section 100 of CPC. CPC, huh? Pending return of the please, comma, I deem it appropriate to suspend the further proceedings of the procedural appeal, the civil appeal number 04/2026, pending before the civil judge, within brackets, senior division. Disturbed accordingly. Is as well as the order dated 13/03/2026. That is okay. Accordingly, further proceedings of civil appeal number so and so shall be suspended. Next paragraph.
जमीन का नाम क्या है देगा
Further, on consideration of the issue involved as regards the dispute involved is of land dispute between the parties, comma. It is provided that parties to maintain status quo till the disposal of the revision. It is made clear that no activities shall be done either by either of the parties.
Shall not enter or carry out loss.
shall not enter into the disputed land or carry out any activities by either of the parties.
Can it be, my lord, fourth, my lord, then, my lord? No.
Ah,
Fourth of the,
They agree to then constitute the parties. No, not is it. List the matter on for
For consideration.
Item number 2,
for admission.
Admission. Lords.
My lord, this is a
Yes.
this is the joint petition
Ah,
praying for quashing of the criminal proceeding pending before the honorable
Mr.
KPOC.
K. Posilan, counsel for the petitioners. Petitioners.
Yes.
This is an application under
Yes.
520 of BNS 2023, praying for quashment of the criminal proceedings of GR case number 102 of 2024. Under section 333, 323, 427, 506, 34 of IPC 1860. On the basis of
Settlement.
with the parties.
Parties.
Mr. T. London additional BP. That's appearance on behalf of the state. All for the scan copy.
Yes, madam.
Of the trial court record. Next paragraph. Pending. No, the scan copy of the trial court record.
Yes, my lord.
Yes.
Next date. But the proceedings of the GR case so still remains suspended.
My lord, that may be mentioned, my lord. The court may be mentioned, my lord. Judicial magistrate first class.
First class.
First class UPI.
Yes, my lord.
Yeah. Naharlagan UPA.
Naharlagan or UPI?
Naharlagan.
We have two JMFCs.
Yes.
Yes, my lord. There.
Naharlagan
Three JMFC.
Now this is
This
JMFC Naharlagan or UPI?
this is JMFC Naharlagan at UPA.
that means this is jurisdiction is Nahalagan, but
Yes.
situation at UP.
Then it is JMFC Naharlagan at UPI.
Yes, my lord.
Next.
Obliged.
Next.
item number 3,
May I please, my lord?
Yes.
My lord, I have this application has been filed under section 528 of BNSS for quashing of the FIR dated 27/10/2025,
Ah.
registered as ETA-WPS case number 19 of.
So,
Yes. My lord.
and
My lord, this is on merit, my lord.
Huh?
This is on merit, my lord. Yes, ma'am.
maybe we cannot. Can we not issue notice?
Yes, oh, absolutely, my lord. I thought, my lord, because most of
Mr.
Biniarus.
Being there, which learn counsel for the petitioner. This is an application under section 528 of the BNS 2023, seeking quashment of FIR dated 27/10/2021, being registered as Eternal Government Police Station case number 19 of 2020 under section 69 of BNS 2023. Next, but I issue notice interval for 3 weeks.
My lord,
No, there, Mr. T at the learned additional people disappearance they are state. Next, but the learned counsel for the petitioner to take steps for submission notice. For respond number 2.
yes, my lord. My lord, by usual course, my lord. Or through register post, as well as through register post.
Call for the scan copy of the CD. Guess that.
Yes, my lord.
Guess that.
Yes, sir. Yes, ma'am.
item number 4,
Obliged, man.
May I please, your lordship? Lordship, this is a joint petition filed under section 528 of BNSS, P. Lomdak.
Learned counsel for the petitioners. This is This joint application is filed under section 528 so seeking passment of GR case number
241 of 23.
section 326, 447, 448, 427, 558, 438, big 32 IPC. Yeah, take it properly.
Your Lordship, I'd like to make an interim submission. Your Lordship, interim.
Ms. MSL Hage, London Edition PP, enters appearance on behalf of the state. Expert. So on the basis of last one, you write on the basis of the settlement. Then you write LR case venture. Then call for the scanned copy of the trial court record from
From
When-
JMFC UPR.
UPR.
just write also at the when it's going to JMFC UPR. Call for the scanned copy from JMFC UPR. Then pending production of pending the receipt of scanned copy of trial court record. Further proceedings of so and so remain suspended.
Obliged lawsuit.
Not serious.
Your
They are
Lordship.
settlement lawsuit,
Yes,
Not serious.
not very lawsuit.
Market.
Only
no,
market
your
lawsuit,
Lordship, in
simple
the
injury.
MLC report as well, the injury is simple.
Obliged
Yours,
Mistake.
yes, Your Lordship.
lawsuit.
Hi, and deeply obliged.
Matter number 5 to 7.
Lordship,
Yes.
this is a similarly situated case. 5 to 7 is,
What is
some of the advocate has not come here. They are from Guwahati. Can this matter be adjourned? After maybe fix up
the
to
prayer of Mr. Tita Pagani versus
Yes.
you are both petitioner.
Yes.
Petitioner in all the cases.
All the cases.
Item 7.
Nobody is at
5, 6, and 7 lawsuit.
No, item 7.
item 7. I'm feeling on behalf of item 7.
This say, not appears for the petitioner in WPC criminal petition 212 of 2024 and 213 of 2024. Our please, Mr. T. Tapak London Council petitioner in criminal petition 88 of 2025 and Ms. MS Elhage London are present. Next prayer is prayed for that this matter will be listed after 4 weeks.
Forward.
Lawsuit.
3 weeks.
3 weeks
3
lawsuit.
weeks.
3 weeks.
And lawsuit, updated case diary may be called for lawsuit.
This is a quashing.
You question
Quashing
lawsuit?
of FIR.
Yes, lawsuit.
The next date, MS Elhage London additional PP to produce the updated case there.
Lawsuit.
Can copy of the-
Yes, lawsuit. Much obliged.
Item number 8.
Yes, Lordship, I'm for the petitioner.
Yeah.
I'm appearing on behalf of the conducting counsel, Mr. Tita Bayam. Lordship, kindly make me agent for today, since the conducting counsel is out of station.
You're supposed to file additional affidavit. What sort of additional affidavit?
Here they have partially in piecemeal basis they have settled the matter, and the juvenile who is involved in this case, they have plead guilty plead guilty in the sense no doubt juvenile cannot be convicted. The fine has been imposed to the juvenile. Now they become the adult, but the other accused, they on the piecemeal basis they have settled the matter and approached this court for quashing of the FIR, my lord. So this is the case.
That's the reason they are supposed to file.
Yeah, they're supposed to file the affidavit to bring into record the proceedings which has been done.
Next day we will file them.
As spread for by MS
W. Jena.
W.
Jena.
Jena. Your name is there.
Yes, Your Honor. Lordship.
That will counsel for the petitioner. Your name is not there.
Your Lordship, I'm appearing on behalf of Tita Bayam.
Appearing on behalf of Mr. T. Taba. Then council for the petition. Further 2 weeks time is granted to file application. Mr. T. Mr. is present.
Obliged, madam.
Item number 9,
Lordship,
Hmm.
there is an interim order.
The interim order pass and yes.
Obliged.
May I, my lord?
Yes.
My lord, I seek permission to withdraw this criminal petition. Instruction from
Mr.
G. Kato.
Your name is there.
Yes, my lord.
Item 9.
Yes, my lord.
Where is your name?
Oh, on behalf of Tito.
Huh?
On
Your name is your name, please.
G. Kato.
G. Kato. It doesn't show. You are on behalf of
Tito.
Tito. Then council appearing on with Tito who submits that he has an instruction to withdraw this criminal petition accordingly. The withdrawal is accepted. The withdrawal is accepted. Accordingly, criminal petition stands closed. The what is this CD?
TCR.
Huh?
TCR.
TCR.
Lordship.
This is original or what? Scan copy. Should we return it? No.
9.
You record her name also. Yes.
Item number 89,
Much obliged.
Huh? 89. What do you mean? It's 9, 10, 11. Yeah. 10 and 11. What is this?
Well, this quashing petition, a criminal petition challenging the entire CBI proceedings. When our pleadings are completed, this item number 11 is connected. It requires substantial time for hearing. My lord.
Cannot be done today.
May not be possible.
Mr. Learn counsel for the
Item 10.
petitioner in criminal petition 194/2025 and
For the petitioner.
in item 11
Yes.
and MS
P. Borang.
learn counsel appearing on behalf of
Titaba.
Titaba is not there. N. Hondik and Punung Borang is there. For criminal petition 140 of 2024. Mr. Well, you will say heard, na? Heard. Therefore,
Lordship, I'm appearing on behalf of M. Kato, Standing Counsel of CBI, Lordship, for the respondent, Lordship.
so MS
Waigao, Lordship.
for CBI. For CBI.
Interim,
That's for.
Huh.
But then counsel for the parties.
my lord, the interim order is operating in my case.
That will be listed after.
4 weeks.
Or will admit it. Admit it and listed for hearing.
No, my lord.
Okay. 4 weeks. Interim order passed earlier self-control. Yes.
We are grateful.
Obliged, Lordship.
item number 12,
May I please, Lordship? Lordship, here, the one connected matter, criminal petition number 320 of 25 has been fixed on 25/5. So may I humbly phrase that this is connected matter.
You heard Mr. K. Lowell and counsel for the petition and also Miss MS. The heard so and so and MS El Hagel list the matter along with
Criminal petition number 320 of 25 on 25/5.
2026. Yes.
Deeply obliged.
item number 14,
What is this?
My lord, there is an IA application, my lord, for delay of 2,582 days, my lord. I filed an objection, my lord, and they filed a reply, my lord.
Yes.
Sir. 582 days. Almost 7 years, my lord. So therefore, I am objecting it, my lord.
I'm sorry. Actually, there's a delay of 2,555 days.
Yeah.
That is necessary to be condoned.
What is your explanation?
One of my explanation is that we have not been received the certified copy issued by the learned district, learned CGM come senior,
What did you apply?
applied on just after the pronouncement of the order. That is on 27, I think 7, 2017. And certified copy was also applied on that day. And thereafter the file was missing.
You slept over the matter?
No, my lord,
You did not approach.
that was already the record of that file was missing
Okay.
from the office. So we are totally helpless, my lord.
How do we know that record was missing?
My lord, after submission of the certified copy for obtaining the order, throughout the room, they searched like anything, but they could not trace out the file. That is the mystery of the case. So my client on every day used to visit the office, but they could not give any response.
This is where is the IA? This is the IA. Yes, what is the explanation where you have given?
It page 87 of my IA, para B. नहीं एफिडेविट में है उसमें है
You have applied your the settlement copy on 22/12/2017.
Yes, my lord.
Then
Thereafter, no any response from the office side.
no, see, with 22/2017 you have applied.
Yeah.
Then again, after in the year 2022, as per your requirements, you have applied. Then again, you applied in 2024. How you I mean explain this in between?
My lord, it was first applied on 26/6/2017. Then thereafter, there is annexure in civil division petition number 2, that is 133 page number. There is a prescribed format, and thereafter
In 2022.
17.
No. 17 first you apply according to you.
Yes.
Again you applied second time in 2022.
Second time 2024. Yes.
22, third time 2024.
Yes.
How do you explain this gap? 2017 to 2022. What is your explanation? In fact, we are conscious. It's not the long period, but you will have to satisfy the
Yes. Yes, my lord.
satisfactorily explain
Yes.
the delay. Five-day delay may not be condoned. 1,000, 2,000 can also be condoned, but you have to give the proper explanation.
Yes, my lord.
And as per the pleadings, in your IA, this court is not impressed that you could able to give a proper explanation. Except to say that the files were overnight it was missing. It's also not believable.
So my lord, it can be happen, my lord, because of the certain individuals.
See, 17 to 2,000 is very difficult. How do you explain? 5 years.
7 years.
No. 17 to 2,000.
Yes, my lord. Earlier it was applied on 26/6/2017. Thereafter again on 22/12/2017. Thereafter again 2024.
You have a case on merit.
My lord, because merit on the sense, my lord, as per the my lord, order passed by the learned civil judge. Civil judge, my lord, in
It's a
annexure.
decree. It's an original. What was the case?
Yes, this is about arising out of the title suit, my lord. Title suit.
Title suit was dismissed.
Dismiss.
Then
Dismiss on the ground of, my lord,
what is
some.
the next? Appeal.
My lord, which I have already.
It should be, my lord, yes.
Sir, what I am asking, why I am indicating? Of course, for filing an appeal, you need to, is the assessment file within a time? I don't have to tell you.
Yes.
For that also, you have to file a petition for condemnation or delay. Now, when the title suit is dismissed, the statutory remedy is appeal, not the revision. Unless you can show that there is a jurisdictional or other error committed by the. So reason being, the merit of the matter is also could be a ground for condoning the delay.
My lord.
So whether opening, going into your merit.
Madam, first and foremost thing is that, Madam, as per the order,
My primary view is you file an appeal. You have to appeal the remedy. We'll resume it.
Madam,
We'll resume it.
My lord.
immediately. Madam, I would like to make it short. Short in the sense, my lord, I may be given to liberty to buy before the
To approach the appropriate
jurisdiction, because jurisdiction point is there.
withdraw. Huh?
Yeah.
No, Mr. Peace or learned counsel for the applicant submits that he may be allowed to withdraw this interlocutory application with the liberty to
Approach.
approach the appropriate jurisdictional, approach the appropriate
Forum.
Mr.
Sole respondent, my lord.
Opada and person for sole respondent is present. Huh? Accordingly, the interlocutory application is since closed on withdrawal the liberty is spread for.
Madam, if any delay of this period may also be considered, my lord.
No, my lord.
Obviously, you have to file.
The-
Obviously, you have to file.
Yeah.
Your appeal will not be admitted,
Yeah.
My lord.
entertained, unless you file a condemnation petition.
Yes.
My lord,
This civil revision which is not been registered.
it is registered, my lord. This, they have filed an IA, my lord, for condemnation of the delay, my lord.
Ah.
So accordingly,
So
my lord,
unless the time it is condemned, actually it should not have been registered.
my lord, no,
What will happen to this fate of this?
my lord.
Then same order.
It's the same order may be passed.
Civil revision petition.
Obliged.
Unless it is delay is condemned,
My lord,
should not have been registered.
obviously, ma'am.
We'll see.
It is numbered at 02 of 2025.
Much obliged.
Obviously.
Item number 15.
Yes.
Lordship, on the last occurrence, TC was called for, Lordship, but
Not received.
not received, Lordship.
Heard MS?
KIO, and Your Honor, there is a one interim, so I request you to continue this interim. Interim is the IA number 91.
Earlier, Lordship, sentence was suspended, Lordship.
Yes, Your Honor.
Not been continued.
Yes.
Once it is suspended. No interim is required.
Oh, okay, Your Honor.
No order required. Huh? MS
KIO,
concept of the appellant is present along with Mr. Niloy Leonard, public prosecutor, and
and for responding number 2, Your Honor.
your name, please.
Your Honor.
K. Nyorak for respond number 2. Huh? Register to send reminders for trial court records.
3 weeks.
The matter on receipt of the
Receipt.
trial court record.
Deeply applied.
Item number 17.
Not appears to be. The
Lordship, here TCI has not come yet, Lordship.
Ilhage Leonard is present. Same order. Register to send reminder for trial court.
Yes.
List. After receipt of
This year.
Yes.
this year.
Obliged, Lordship.
Item number 18 and 19.
May it please your lordship. The matter has been compromised between the parties, my lord.
The matter has been compromised between the parties, my lord. During the pendency of the criminal petition, my lord, the matter has been compromised, my lord. There was a dispute of around 6 lakhs, my lord. When the petitioners paid the amount to the respondent, my lord. Now, my lord, in view of the settlement, my lord, lordship may quash these proceedings, my lord.
What is the IA for?
By way of this IMI, we have bought this settlement agreement on record, my lord. And
So,
Yes, Lordship. No, we have already been settled, Lordship.
We have no objection, Lordship.
heard Mr.
RS, Mr. Chairman.
During the pendency,
Of this criminal, there was a criminal petition pending, my lord. During the pendency of the criminal petition, my lord, the matter has been settled, my lord.
what is the offense?
And offense is under my lord section 420, 409, and 109, my lord. Am I cheating?
Learned counsel for the petitioner. And also heard Mr. Deloy, learned public prosecutor. State, as well as Mr. K. Learned counsel for. Respond number 2.
Yes, Lordship.
Next page. This is an application under section 528 of PNSS 2022. Praying for quashment of criminal proceedings,
My lord.
of GR case number 168.
Block.
Arising out of Pasigat case number 1. Under section 420 of 419 of 1960. Pending the funding. Chief Judicial Magistrate.
Pasiga.
Is
Mr. Who is the FIR?
that my lordship will find it, my lord, page 17, my lord. And operating part, page 19, my lord.
This is against someone for those.
Respondent,
You are Rajiv Agarwal.
yes, my Rajiv Agarwal and Marbi Bam, my lord. They are two petitioners, my lord.
In that case, petitioner, sir. The criminal proceedings was set in stone motion pursuant to the FIR lodged by the respondent number 2 on 10/07/2018. On the allegation that the petitioners have cheated,
My lord.
cheated the respondent number 2 by promising by promising to finance a loan amount of rupees 74 lakhs.
My lord.
You have paid the amount.
Yes, my lord. We have paid 10 lakhs, my lord.
Not bank loan.
Not only 6 lakhs was taken, my lord.
The respondent number 2 was made to pay a sum of rupees
6 lakhs.
to the petitioners. List of the petitioners had promised that they will complete the non-project on or before 2018, 20/01/2018, which will be for sanctioning. Mr. After receipt of the amount of rupees 6 lakhs, despite several approaches, the petitioners have evaded, which put the respondable to evaded by not responding to the respondent number 2, Mr. Next minute. Pursuant thereto, a case was registered being Pasigat PS case number
131,
131 of
2018,
2018.
18 matter under section 406, 409, 419, 420, 34 IPC.
Next one, charge sheet has been filed.
Yes, my lord, page 20.
After the completion of the investigation, no, on completion of the investigation, the charge sheet was filed on
It was filed, my lord, on 11/2022.
section,
My lord,
same section, no,
same section, my lord.
again,
Lordship.
petitioners. Charges had been framed.
Framed. Lordship filed page 27, the order framing charge, my lord.
Charge, the learned trial court has framed the charges against the petitioners.
Lordship will find page 30, the charges, page 30, last page, my lord. My lord, against the petitioner number 1 matter, charges were framed under section 420, 419, and 409. And against the petitioner number 2, charges were framed under section 109 and 420.
Frame the charges against petitioner number 1, that is 420, huh?
My lord, 420, 419,
19,
and 409.
and against the petition number 2, 109, 420.
Only on 2 charges,
419
my lord.
IPC. Initially, what is your ground of challenge?
My lord, the ground of challenge was it is civil in nature, my lord. Though there was a promise to do work, it couldn't be done, my lord.
Mr. RS, Mr.
My lord.
Counsel to the petitioners submits that the present petition has been filed for quashing the criminal proceeding. The pursued criminal proceedings on the ground that the dispute is purely of civil nature,
My lord.
where no criminal liability fixed on the petitioners. However, during the pendency of this criminal petition, the parties have settled the matter on when?
8/4/26.
8/4/20.
26.
Page 13 of the IA, my lord.
8/4/2026. When parties have 10 lakhs.
Yes.
My lord, 10 lakhs.
Yes, lump
They
sum.
have certain amounts amount of rupees 10 lakhs to be paid to the respondent number 2
My lord.
as the same was purely a civil dispute arisen out of business transaction.
My lord.
Business transaction. Yes. Next. Mr. Deloy Leonard, public prosecutor for the state, and Mr. Kelon and counsel for the response have fairly submitted that in view of the settlement between the parties, the criminal petition may be set aside as it appears to be a purely civil dispute which has arisen out of business transaction. Next, consider the submissions of the consequent parties. Also, there is the materials of the court. No case record. Case. There is no record.
No, Lord.
Next paragraph. The criminal proceedings appears to have been initiated on the complaint, public FIR, by the respondent number 2, alleging cheating, essentially, the allegation, essentially alleging cheating by the petitioners. Mr. Completion of the investigation, the police has filed a charge sheet, which is pending, which is filed a charge sheet, and accordingly, the charges have been framed against the petitioners under section all the sections, last 2 sections, 4 sections. Next paragraph. On perusal of the materials brought from the court, it appears that the transaction alleged to have been made between the petitioners has been made for business transaction, which prior precedent, which a dispute could at best be a dispute of civil nature. Mr. Be that as it may, the parties have settled the matters wherein the transaction of wherein the petitioners have paid the respondent number 2 a sum of rupees 10 lakhs, which has entitled to the respondent number 2 on so and so 8/4/2026.
Yes.
For which settlement agreement has been for which an agreement has been entered into buyout settlement system. Having considered that the dispute is of civil nature, and also considering that the parties have already settled the dispute, I did it. I'm of the considered view that the present case is one of the cases where the inherent jurisdiction of inherent power of this court is required to invoked according that's the criminal proceedings so and so so and so.
In GR case number 160 of 2018, pending in the court of Chief Judicial Magistrate, Pasighat, my lord. So maybe cost, my lord.
Stands cost, huh? Criminal proceedings stands.
Deeply obliged, your lordship. Matter number 20.
GB.
Mayor. Yes.
Yes.
Yes, Lordship, this interlocutory application is for condonation of delay of 23 days. 23 days delay in filing revision. This may be condoned. No notice issue. Today it is motion. Yes. Maybe. Yes, in both the case. A connected matter. Applicant. Tricks. Response, all respondent only. Only one response, all respond. Item number 20 and 21, both the case. That is same Nazar case, except party is different. Same order, party is different. Same impugn order, yes. Okay.
Item number 22 and 23.
This matter was those two page in even the brief is not with us. Brief is not with me. Page in your these out of the station. Will be tomorrow. And also this matter may be taken up tomorrow, Lordship. So it's break is not with me. Others is no idea, Lordship. Yes. Yes, it's twice. Yes, it's 22. Yes, Lordship. Yes, no, it's. Whether completed with sentence. No idea, Lordship. Since this is not. It's for. Yes, it appears maybe, Lordship. Just go to the 12/12/2020. 12/12/12.
Matter number 25.
Yes. You're already doing.
No, I'm not aware of that.
Sentence.
The sentence, yeah. Huh? Hmm.
Thank you, I mean, not you.
Yes.
But then just because it has been released.
Yes. Yes. You know, actually, I was just when the matter was given, I was on that because the punishment which was given, he would be almost completing that one. That's why the matter should be argued early, but due to many other factors, the matter could not be heard. Now, in this matter, the conviction itself was wrong, in my humble opinion, because in the judgment itself, the presiding judge says that it's not sure how the victim died, but it's due to pulling and pushing or by the slab. In any way, there's no conclusive proof that due to which factor the deceased succumbed to his injuries. That is nowhere there. And we cannot deny the statement of the one single eyewitness.
Yes.
There some PW6.
Then
Yes. No. Yes. You know, in the paper book, if you see the page 719, this is the confessional statement recorded by the magistrate. Well,
Page 19 is the confessional statement. 1919. On 19 August 2014, around 7 p.m., my uncle, my father's youngest brother, came back to our house and started peeing on the veranda. Hungu, seeing that, I scolded him and asked him not to pee on the veranda as it would stink. Also because it is summer time and people prefer sitting on the veranda. Then my pai, Sri Tabang Saro, punched me and hard on chest, and I was angry. I slapped him twice. Then I went away and didn't return home for a day, and I'm not aware of the incident that occurred after I left. This is the confessional statement of the accused. Yes, yes. Accused simply says when his father, brother, came and started urinating on the veranda, he scolded him. Of course, he was said he was drunk. When he was scolded, he instead attacked the accused.
You're the
Victim. Yeah, I'm the accused person. This uncle was the deceased. So he, according to confessional statement, he gave 2 slaps and left after.
Yes.
Now, PW1, page 21. I know that page 21. I know the accused person standing on the other. He's my paternal uncle. I know that I have been summoned as a witness. In the night of the said incident, accused was with me in my house. He thereafter went back to his house. I was still in my house with some of my friends and could heard hue and cry made in the house of the accused person, as his house is located 40 meters away from my house. I, along with my friends, rushed to his house and could find that his father was lying unconscious. Accused standing in the door told me that had some altercation with his father. When there was a push and pull between them, father sustained injuries and has become unconscious. I immediately arranged the auto rickshaw and took the unconscious father to General Hospital PSG, where MO has declared him brought dead. I did not see the incident in my own eye. In this case, as per our customs, we brought back the dead body to our village and kept the same in his house for some time. But as said here in before, we had to bury the dead body, and then there, as per the custom prevailing in our Adi community. As per our custom in our Adi community, we don't keep dead body in the case of unnatural death. We therefore suggest the accused persons to stay away from the village at least for a month, who is done as per custom. The accused was staying in a farmhouse about 3 to 4 days. OCPS PSG came to our village and has made an inquiry. He stated before us that we would have informed such incident to the concerned OC. Thus, after having registered the affair, my father, who is the own brother of accused person, was suspended from his service. Since then, he was working as head constable in police department, having not informed the concerned authority about the incident. This was my grandfather, of which my father is eldest son. FIR was lodged by me. I wrote the FIR and dictated by the OCPS, Pasiga. Accordingly, accused was arrested. Exhumed such and such is there. In cross, he simply says dead body was exhumed after 2-3 days of the date of incident, and examination of dead body was done here on the spot itself instead of taking it to the medical. I have not seen the incident with grandson of the deceased. He is not an eyewitness. He hears a witness which he heard the incident from the accused. That there was pulling and pushing between them, a scuffle, and father, that maternal uncle, fell and became unconscious. A paternal uncle, no. PW2. This is the, yes. The, yes. But both, this is what their paternal uncle. I have not seen the incident with own eyes, but I heard that there was a fight between my accused brother and the deceased paternal uncle, for which we had to be taken to medical. The said paternal uncle was staying with the house of my accused brother. I later heard that my said uncle has died at the medical. The villagers accordingly buried dead body in the night itself, as per customs prevailing in our community. The police authority came to our village after 2-3 days from the date of the incident, and dead body was exhumed for examination. As per the information I have collected, dead body was examined there at the burial place itself. Now PW3, he was declared as a hostile witness. I know the accused standing on the dock and in relation, he is my son-in-law. I was not asked anything about the case of the police. I do not know anything about the case. So in the PP cross-examination, I know Tabam Saro, but I do not know anything about the incident. As I was away at Mekong village at the time of incident, I was staying with my son at Mekong village. I heard about Tabam has died, but I did not know how he has died. I know Pratima Dai, who is granddaughter-in-law, who is looking after me. It is fact that I was informed by my side daughter-in-law about the incident. It is a fact that I was told by my daughter-in-law that there was a scuffle between the accused person and disease in which disease died. This granddaughter. PW3. Father-in-law. Accused. All are relatives actually. PW4 is not required because he has, so he didn't say anything. PW5. Yes. I know the accused who is standing in the dock. I came here to on receive summons. He is, he might be related, but it's not there here. Yes. Berung village, I came here on receive of summons. Person standing in the dock has fought with his paternal uncle. I have not seen the incident. I do not remember the day and the date of the incident. I heard that took place in the house of the accused person. I also heard that accused paternal uncle pushed him, and who, while doing so, fell down near the door and sustained injuries on his head. I do not remember who told me about the incident out of the many villages. The said paternal uncle has died. He must have died by falling down near the door. The accused did not come to my house on the day. PP has paid for that. He was declared hostile. Now, PP's cross-examination. It is a fact that deceased was unconscious after the incident. Thereafter, he has been taken to medical where he died. It is also a fact that dead body was taken to village and buried as per customs. I was told by accused person that deceased first assaulted him later. On next attempt, the deceased person, while trying to assault, lost his balance and fell on the wooden door lying near veranda. This is how he died. It is a fact that accused person informed me about the fact at around 10 p.m. in the night of said incident. So this is there are two versions. One is that the accused persons gave two slaps according to the confessional statement, and all other statement says that scuffle, and it was the disease who, in the second time, while trying to push, lost balance and fell on the ground and hit on the wooden floor, head. That's now PW6. Yeah. She is the lone eyewitness to the incident. The person standing at the dock is my father. Being the daughter of the accused person was taking meal at the point of time. I saw the incident with my own eyes. My grandfather was drunk and urinated on the veranda of the said house, for which my father scolded him. On being scolded, yes, she was there while this scuffle took place. On being scolded, said grandfather pushed my father, and while doing for second time, he lost his balance and fell down. He sustained head injuries for which he became unconscious. I got up and poured water on his head, but could not regain his sense. He was thereafter taken to medical, but he was brought back home dead. My statement was recorded at police person, but I told him that I did not know anything about the case. Yes, fourth line on being. Yes, push. This is a yes, fine. Yes. Yes. In the cross-examination, why did not you tell the truth to the police? I got scared because my father was taken into custody of police after the said incident. Yes. Thereafter, no cross-examination because, and yes. Yes. No, it ought to have been the, if the public prosecutor wanted that she was not telling the truth, then the PP should have cross-examined him after declaring him as hostile.
Okay, depends with the obvious.
Yes, yes. Yeah. Now, next is John Modi. It's not important as such. No, he is no Gangbura. No, working EAC and the inquest and all that exhumation of the body is not necessary. Now, Dr. PWA is Dr. Riso.
Yeah.
So page 32 is the opinion, medical opinion. As per my opinion, the deceased died due to cerebral hemorrhage following blunt injury on right side of the axillary bone, and the said injury was sufficient to cause death of a person in normal course. One blunt injury, that's all. PW 9 is the IO of the case. So he has given the investigation details of his investigation. Now, PW10, the magistrate which recorded the statement. This is the statement which I already shown this honorable court in the first place, the same statement. And there was no any cross-examination regarding that. Yes. Yes, he slept. Yes. Yes. Then thereafter, if the honorable course, yes, sir, there's 313, page 37 it starts. Yes. No, nothing. Ma'am. Yes, sir. No, judgment starts from page 47. Initially, all the recitals, has given the details of the incident and deposition which we have already read. And if we see the analysis only, this honorable court, because otherwise all the things are the same. No, Your Honor, it starts from page 68. Let's read from para 43. The informant has been examined PW1 during trial. He has deposed that in the incident night, accused was with him in house. He thereafter went back to his house. He was still in his house with some of his friends. It could not hear hue and cry made in the house of the accused person, as he was located 40 meters away from his house. He, along with his friend, rushed to his house and could find that his father was lying unconscious. He further deposed that the accused, standing on the dock, told him that he had some altercation with the father and there was a push and pull and between them, and said father sustained injuries and has become unconscious. The evidence of PwC witness reveals that accused scolded the deceased and deceased pushed the accused, whereas evidence of informant who immediately present at the PO after the incident reveals the accused told him that there was an altercation between the accused and the deceased when there was a push and pull between them. His father sustained injuries and became unconscious. Now, the learned court want to say that the evidence given by PW1 is reliable and not of PWD6, who was the sole eyewitness. And his statement was not cross-examined by the public prosecutor, and it's a prosecution evidence. In my humble opinion, the eyewitness should have been given the more weightage in criminal trials, because she was the sole eyewitness in the incident. PW6 is daughter of the accused and deceased is adopted father of the accused, and thereby PW6 is adoptive granddaughter of deceased. Hence, she might have. That's why the manner in which the conclusion has been derived is all kind of imaginations only. No, in the record, nothing is there. That no, but he has some inclination that is all conjectures and surmises, because she is daughter and she will be in favor of his father. That cannot be the ground for conviction of person. Authority. She might have inclination towards nature of father to defend the accused father. However, pushing from the side of deceased exists there. It may also be possible that she viewed it from side of adoptive grandfather. In such a case, a position, if the accused has pushed and then pulled the deceased in full force, it cannot be seen from the side of deceased grandfather in its natural course of action. During the trial, none of the parties ever tried to extract it. Pulling and pushing between two persons holding clothes in evening time may not be seen even by eyewitness as it goes in a fraction of a second. It was evening, but whether there was availability of light at the time of incident is also not brought to the record during the trial, either by party during the examination, cross-examination of PW6. This is something bizarre, the learned trial court is building up its own stories here. He says it might, because it might have in fraction of a second, even the eyewitness could not have seen the incident. And all these things are not in the from the record. It is undisputed fact that after the incident, deceased became unconscious, PO, as per PW6 and PW7. The evidence of PW's personal information thereof from accused about altercation, pulling and pushing between him and deceased, it is an extrajudicial confession immediately after the incident without any force or inducement. It does not suffer from legal infirmities from all angles. He also heard and yes. He says it's a kind of extrajudicial confession. It is not an extra. Yes, yes, from the accused. Yes, yes, yes. So from legal information from all angles. He also heard hue and cry at the house of the accused, rushed to PO immediately at 40 meters from his house. Evidence PW has not been impeached by the defense during the trial. But rest of that citations, Again, to impeach the statement of the eyewitness. Now, no, the head, it's on the wooden floor. That's the statement.
House one attempting to push a person.
This is the extra. It is nowhere there in the record. Every witness say it fell on the wooden floor. And the unwavering statement by PW6, and it has not been contradicted by the prosecution. And it has to be taken at its face value. How the criminal court can discard his evidence in totally like this manner. Nobody said this fell on the wooden floor. I'm sorry, bamboo floor. Now, 49. Therefore, I am not in position to agree with the evidence PWC. This had fallen while attempting to push it accused and became unconscious. It's not even naturally possible to sustain injury resulting to extent of unconsciousness, died by falling on surface of bamboo house. Now, the learned court wanted to say that the bamboo matting kind of thing, if one falls, one cannot die. But the evidence says it was on the wooden floor. Therefore, this is not unbelievable and unnatural. As such, this particular part of evidence is rejected now.
You see, in 313, there are 55.
Yes.
Because during the examination of action on 313, when replying the accused admitted to kill the deceased, but he had no malevolent intention to kill him. Where do I get it here? 313.
Yes.
Three zero two, 304 part 2.
Yes. I'm sorry, I didn't get where that has come.
Para 55.
Yes.
It is also records during examination accused under 313. While replying, the accused admitted to kill the deceased, but he had no malevolent intention to kill. What is 313?
It starts from page 37. I didn't see such sentencing.
Okay, for me,
I guess.
techniques, yes.
Oh, that's in page 44. That's obvious, he didn't have the intention.
Due to salute what was happening. Yeah, let me tell you what do it is correct right now. Well, it doesn't say so also.
Yes.
Is the admission here?
Accused didn't admit to kill you. This is just opposite of the what 3-1 statement.
Yes. Any judgment?
Now, you're just para 57. Para 57, I just want to read that paragraph only.
Yes.
The evidence of the doctor is complete corroborates the evidence PW1, confessional statement by accused besides corroborate hearsay evidence of PW2, PW5, whether injury was sustained either by slapping, the disease, or as per confessional statement of accused by pulling or pushing. This is just opposite. Confessional statement says slapping. Pulling was heading to become unconscious of the decision. POV says PW6 says seen at the time of incident. PW1 immediately after incident. The doctor declared disease brought death clearly shows that disease died resulting force given by accused either by slap or by certain degree of force during pulling or pushing, sustained injury which was sufficient to cause death of person in ordinary course of action. Moreover, this is for old age person who could not able to prevent the force given by him by the accused due to old age factor. Now, you are this honorable court may kindly see the criminal law is crystal clear. The cause of death has to be certain. The presiding judge itself in this paragraph says that cause of death is not known how he has died, whether it was pulling or pushing or by its by slap. So unless a prosecution proves the guilt beyond reasonable doubt, by presumption, conviction cannot sustain. So, in my humble opinion, the
Conviction or suspicion?
yes,
Presumption.
presumption, totally. The conviction could not have been done. At least a benefit of doubt could have been given and acquitted the accused person.
Yes.
Otherwise, these citations are not required anyhow. I'll just this. I'll not read this. Sir.
Yes.
Para 17.
You don't have SEC.
Yes, corresponding SEC ought to have been given. This is Supreme Online.
Yes.
I'll just read that paragraph. It is true that this case of brutal murder, brutal offense does not dispense with the legal requirement of proof beyond a reasonable doubt. It is this case. In this case, there is a legal evidence proof that involvement of accused. The courts can convict an accused only if its guilt is proven beyond a reasonable doubt on the basis of legally admissible evidence. There cannot be moral conviction. We are tempted to quote what this court observed in para 24 of its discussion that's in case of Subhash Chand versus State of Rajasthan. It is as follows. Because none of the pieces of evidence relied on as incriminating by trial court and the high court can be treated as incriminating pieces of circumstantial evidence against the accused. That the offense is gruesome and revolts human conscience, but an accused can be convicted only on legal evidence, and if only a chain of circumstantial evidence has been so forced as to rule out a possibility to any other reasonable hypothesis accepting the guilt of the accused in such and such. This court caution human nature is too willing when faced with brutal crime. So spin stories out of strong suspicion. This court has held time and again between may be true, must be true. There is a long distance to travel which must be covered by clear, cogent, and unimpeachable evidence by the prosecution before the accused is condemned to convict.
There are 17.
Yes.
Then
Of course, this is a only paragraph 32 I'd like to read. This is regarding evidence.
Mirror,
32, last page.
last page.
Yes.
Hmm.
It is more than settled principle law that if two views are possible, the benefit shall always go to the accused. It will be opposite to refer the following observation of this court in the case of Sharat Biridachan Sardau Supra. We then pass on to another important point which seems to have been completely missed by High Court. It is well settled that where the evidence, two possibilities are available or open, one which goes in favor of the prosecution and the other which benefits the accused. The accused is undoubtedly entitled to the benefit of doubt. Here are two views are possible there. So the possibility that the majority of the evidence that has come is that when the deceased tried to push second time, then he fell on the ground and hit on the wooden floor. And it's not a benign fact that he was drunk also at that point of time. That is on the evidence. That's all.
So that he was drunk?
The disease was drunk. That's why he was urinating.
No, from where?
The statement of PW6 clearly shows.
Is there anything medical?
No, because his body was exhumed after 3 days. Therefore, I want to pray this honorable court, the accused ought not to have been convicted, but discharge on benefit of doubt ought to have been given.
Acquitted or discharged?
Acquitted by on benefit of doubt. That's all.
So now suppose if the appeal is allowed, what would be the...
Some compensation from the government should be paid. After all, he has suffered more than 3 years.
No, the fine which has deposit can be refunded back.
Apart from that also, the prosecution, the suffering for more than 3 years is not a small thing.
Yes.
Lordship, I have a submission to Lordship.
Yes, obviously. You'll have to now establish. You have to support the conviction.
Lordship.
Yes.
Lordship, in the page 19, Lordship, accused statement, Lordship, can be this before the magistrate 164. May, Lordship.
Yes.
On 19 August 2014, around 7 p.m., my uncle this came back to our house and started peeing on the veranda. Seeing that, I scolded him and asked him not to pee on the veranda as it would stink. Also because it's summertime and people prefer sitting on the veranda. Then uncle punched me hard on my chest, and I was angry, and I slapped him twice. Lordship, this slapped him, Lordship. He has stated that he slapped him twice. Then I went away and did not return home for a day, and I'm not aware of the incident that occurred after I left, Lordship. And Lordship, this will corroborated with the statement of the IO as well as the MO, Lordship, this medical officer, Lordship. IO, Lordship, I'll take to statement of the IO, Lordship, PW9, Lordship. Page 34, Lordship. May, Lordship.
Yes, yes.
Second paragraph, Lordship. During the course of investigation, PO was visited. The PO was in the house veranda of the accused person at the Bedung village, and I have examined the complainant and other witnesses and recorded their statement in separate sheet paper, which is enclosed in a charge sheet. The accused person was arrested and interrogated. During the interrogation, the accused person have stated that on 19/8 to 14, at around 19, a stepfather came to his house and started to pee on the veranda. On seeing, he scolded his stepfather and asked him not to pee on the veranda. It would be stink during summertime, and the people also used to sit on the veranda. Then his stepfather punched him hard on his chest, so he got and slapped him left and right cheek, due to which his stepfather became unconscious and fell down on the house veranda. That is in his statement, Lordship. And again, Lordship, PW 8, Lordship.
He did not say so.
Lordship,
In
as
the
per
statement
statement, yes,
that
Lordship.
he fell down.
Yes, Lordship.
Due to
Before,
his-
yes, Lordship. Before IU also, he the same statement, Lordship, and before the magistrate also, Lordship. And what?
No, this is different. He said, then citizens punched me hard on my chest. I was angry and slapped him twice.
Yes, Lordship.
Then you did.
Due to which his stepfather became unconscious and fell down on the house veranda.
He doesn't say so.
Lordship, due to which, Lordship, because Lordship, in the statement or before the magistrate, Lordship, he accepted that I slept in bed. After
No,
that, I
slapped
went
him,
away.
Okay, we understood.
Yes, Lordship.
But there's nothing like a statement that due to which become unconscious and fell down.
But Lordship, the slap, Lordship, this part is there, Lordship. In the board, yes, Lordship. And then Lordship will go to the Lordship statement of the Lordship, MO Lordship, medical officer, this page Lordship, PW8.
31.
Yes, Lordship. 32, Lordship. The opinion of the Lordship, this MO, this medical surgeon, Lordship. As per my opinion, the disease died due to cerebral hemorrhage following blunt injuries on the right side of the maxillary bone. Maxillary bone is the jaw part, Lordship, jaw area, Lordship. Maxillary bone, which is connecting the jaw line, Lordship. And the said injury was sufficient to cause the death of a person in the normal course, Lordship. That means, Lordship, the slap, Lordship, it was so hard, Lordship, that it can, Lordship, be fatal, Lordship.
Blunt injuries on the right side of the maxillary bone. Where is maxillary bone?
It's a jaw area, this side, Lordship.
Yes, it's like
Yes, Lordship, so hard, Lordship, because that is all.
not the jaw.
Lordship, that's part, Lordship, but this connecting bone of this jaw area, Lordship. But I've just got to the Lordship.
Yes, yes.
And that,
I also got to
yes, Lordship.
his maxillary bone.
Yes, Lord. And the said injury was sufficient to cause the death of a person in a normal course.
Blunt injury.
Yes, Lordship. And this is
Happen,
that's why Lordship 304.
falling down.
Yes, Lordship. Because if you got so
Falling down.
yes, Lordship. If you got that much of heart,
It
Lordship.
could be, sustained on he being fallen down.
Yes, Lordship.
On the wooden floor.
Yes, Lord, on the dead part.
Not necessarily due to this thing, slip.
Lordship, because the slap, if he hit him hard on the dead part, Lordship, it can be fatal, Lordship. Of course, after you have got that kind of Lordship. Lordship, as per this
But they didn't.
PW6, Lordship, eyewitness,
313, they said
in the 313,
it was not hurt.
no, Lordship, 313, Lordship, we'll go to the 313 again, Lordship.
So according to you, this is support corroborated.
Yes,
by
Lordship. Statement, his own statement.
is corroborated by the PW 8 and 9.
Yes, Lordship. 8 and as well as his own statement before the magistrate 164, Lordship. Lordship, in the 313, Lordship, where PW9, Lordship, the question when arrest, Lordship, that the further you said there was no malified intention to kill him or harm him due to sudden provocation. It was happened. You admitted your guilt. What do you have to say on this? Then his answer was that, Lordship, it is correct that I had no intention to kill the disease, but it was done on a sudden provocation. That means he hit him, Lordship, at that point in time. That he caused some injury.
Where it is, where
In the page, Lordship, 44, 313.
44.
Yes, Lordship. Question, Lordship. PW9 deposed that further you stated that. Yes, Lordship.
But due to certain was happened, you admitted you have did. What do you have to say? It is not correct that I had no intent.
It is correct that, Lordship.
But then certain
Lordship, yes, Lordship. That's why, Lordship.
This is punch him.
Yes, Lordship. Yes, Lord. That's why, Lordship, he died, Lordship, because of old age, Lordship. Maybe there was no intention, but he did not deny that he did not do any harm. He accepted, Lordship. He admitted that he had some harm was caused, Lordship. But the thing is, Lordship, the intention was not there. That's why 3042 was applicable in this matter, Lordship. If the Lordship intention was there, then 302 will be was attracted. But 305 minimum, Lordship, only 3 years. The punishment is 10 years, Lordship. And there's no defense witness also. Only PW this collaborated with his own statement also, Lordship. The 164 as well as IO of the this investigating officer, Lordship, and MO also, Lordship, the medical officer statement. So, Lordship, my humble submission that, Lordship, the minimum conviction which was awarded is rightly correct, rightly convicted, Lordship. And now he was already discharged, Lordship. So,
discharge.
no, I mean, he's already released, Lordship.
Completion
Yes,
of
completion of, yes, Lordship.
That's all.
Yes, Lordship, it's my humble submission, Lordship.
That's the evidence as such.
But, Lordship, one old man has died, Lordship.
Inference.
One old man lost his life, Lordship.
Conviction on inference.
Whatever, Lordship.
You know better than us.
Lordship,
Criminal jurisprudence.
Lordship, it is, Lordship, I am, Lordship, fairly submitted that maybe, Lordship, prosecution part was not fairly done, Lordship, but the statement, the Lordship, the PW's, Lordship, it is corroborated, Lordship. So somehow, Lordship, it is evidence is there that he died due to some fault, Lordship. Maybe, Lordship, that it's unfortunate that it has fatal for him. Otherwise, Lordship, maybe he could have survived also.
Had he been survived, we would not have heard this matter today.
Then it may be, Lordship, settlement was also there, Lordship. He may have settled also.
Okay, that's all.
Yes.
Any judgment?
No, Lordship. Today, actually, I thought, Lordship, their hearing should not be.
Why the matter is fixed for hearing? Why?
Lordship, actually, I have gone through the, Lordship, that order, this report, Lordship, that they have already.
There's a bad impression in the principal seat. To this bench now.
Actually,
Again, this bench was supposed to be best bench among the hotline benches.
after
Now things have changed. The impression has changed because of this the adjournment culture.
Yes, Lordship.
Which
It's very unfortunate, Lordship, that this matter has come up after long, Lordship.
Positive time may not,
Yes, Lordship.
it may be, but it is listed. I think last occasion also I have indicated.
Yes.
Yeah.
Why the cases are listed for mentioning, unless it's very, very, I mean, unavoidable.
Yes.
On to 29 July, it was listed, Lord.
Especially this record, when I went through, I saw the conviction was totally wrong. That's why I tried many times to settle, to get the. No. It was my opinion that if the matter was heard early, he could have been released earlier also.
Yes. Anyway, can't help it.
Para 57, that is sufficient to indicate.
No judgment.
No judgment, Lordship, because
Your
it's
senior
already.
has stated judgment to authorities.
Otherwise, Lordship, I'll place, Lordship, tomorrow I'll.
No, we're keeping it.
Yes,
It's okay.
No.
I'm not saying that you may not have you don't have a case. Well, keep it CABN.
Yes. Much obliged.
Much obliged.
You're legal aid counsel.
Yes.
Legal aid counsel. They have put it. Also have MS L. Hage, learned additional PP for the state. Hearing concluded, judgment reserved.
Obliged.
Obliged, Lordship.
What understand that? Okay. Yeah.
Number 26, understood.
Understood. May Lordship, in this case, Lordship, this case has been filed in the form of criminal petition because Lordship, the basis of filing this case is Lordship, a case has been registered against the accused person who is petitioner in this case. Kindly see page number 46, annexed 3. This is the FIR. This page number annexed 3, Lordship. As per this annexed 3, allegation is that
Just wait.
yes.
When it is page.
Page number 46, annexed 3. This is FIR.
Yes.
Yes. This is a long FIR filed by a group of persons, including 19 number of persons. The main issue, crux of the issue is, Lordship, this petitioner is having organization called Arunachal Pradesh Scheduled Tribe Board. He is the president. And on that day, there was a case, one case going on before this court also, that the demand of the Arunachal Pradesh Scheduled Tribe Forum was there. This PEC APST certificate, more particularly report has
When
come
this
from,
was filed? 1-3.
yes, page number 46, Lordship.
Any notice?
Lordship, kindly see
Notice of the
page
57, Lordship.
page number 57 is the notice.
We issue
Notice.
notice.
At this, I'm Lordship, I'm trying
We
for,
just said you have been directed to issue notices.
that is why, Lordship, I am to submit, there is no merit in the case. Since even the Lordship, since there is a 530 DNSS,
You
in which
appear, it's not
there is a provision for audio visual recording, virtual recording of the statement, Lordship. Investigation may go on, Lordship, but I may be allowed because it is
no.
on perma facie,
You asked the request
Lordship, it is a Toang, Lordship, and I have already pending case.
if you want to, if you can avail the virtual mode
Yes,
from here.
yes.
Ask. Now the internet is available, everything is
Lordship,
available.
I will personally try to
You
request
request,
it.
no,
Can-
nothing.
Right. Can I, Lordship, if police deny, insisted for coming to this Tawang, this matter, can this matter be fixed after 2 days?
Huh?
After 2 days.
On the prayer of Mr. We'll just fix it after 2 days.
Yes, sir. Tomorrow,
The prayer of Mr.
matter fixed.
Tapak, learned counsel for the petitioner. Let this matter be listed.
My submission is not that, Lordship.
Yes. Huh?
My submission is not
Then-
that. My submission is that
See, it's
tomorrow
very-
I will
you don't
try.
know. It's not.
I'll-
You have. Did you issue did you circulate all this news?
Yes, admittedly,
Then-
Lordship.
Then
Lordship, it is
whether this is-
advisory.
whether it is a fair criticism or not,
Yes, fair
it will be looked into. We'll see.
I have
At best, we'll issue a
made it-
notice. Sir, I will just at best we'll issue a notice. It's just the same state.
Lordship,
Under the law, you have been directed to appear. Notice has been issued. You
Lordship, since 5:30.
you cooperate
in
with
the
the
interest-
investigation.
I will be cooperating, but
That's all.
Lordship, since it is Tuang police,
You approach
before the
the
Itanagar
authority.
police, so kindly see the Lordship. I have even,
Sir, you approach the authority, investigating authority.
tomorrow I will try, Lordship.
It's up
In
to you.
case
We cannot guarantee you.
If the police denied lordship, matter will be fixed for day after tomorrow. I will lordship try to press the matter lordship as per on merit lordship because there is no merit in the FIR lordship.
I've seen that.
Because FIR has been lodged by the unaffected person lordship. Unaffected person cannot lodge such FIR lordship. This is the issue lordship. Day after tomorrow lordship. Even then, my prayer was lordship. Since lordship, there is a provision
You want
500.
you want to issue a notice or not? Or you are
Definitely notice will be issued lordship.
today?
Yes, today.
Just simply issue a notice, nothing else. Huh, Mr. Data Planet Council for the
530 is lordship. Yeah.
Huh?
that is-
No, Lordship, 530 will not, there is no provision for a BC, Lordship.
There is the why there
No,
is
no.
no BC. This is this guidance lordship. Maybe issued.
530 says something, Lordship, not.
Kindly see the read the 530 provision.
Next
530 of
This
the
is an
DNS lordship.
application under section 528 of
520.
PNSS 2024.
Electronic mode of recording of
praying
evidence.
for Pursuant of FIR dated 01/03/2026 being Tawang PS case, it has been registered.
Yes, already registered. That is why someone is.
What is the number? Tawang PS case number 05
Yes.
2020 under section 196 within bracket 1 bracket was 356 bracket 2 bracket close BNS 2023. Issue notice returnable by 3 weeks. Mr. Is name Mr. Deloy Leonard PP entered appearance and accepts notice on behalf of appears for Leonard Public Prosecutor appears for respondent number 1, 2, and 3.
Yes.
Petitioner to take this to land council to take this procedure of losses of 4
to 22, Lordship.
22. By so and so within 2 days, huh? This start for 3 weeks.
On next date, lordship, for
3
hearing of
weeks.
the interim order. Lordship.
3 weeks.
After
What interim order?
because lordship interim order is either stay or lordship allow to this.
We'll provide you to appear.
Lordship, that is why lordship. It is a Tawang is a
Just
very.
cannot-
I have a security problem,
See,
lordship. That
What
is there.
security problem?
Because
You ask for-
Itanagar,
ask
Thana,
the SP.
Itanagar, already lordship. Even I have filed before there's a high court for provision. There's a police security protection law.
Where?
This honorable court that was disposed and application was filed before the SP security concern. And the SP security concern has opined that if the security problem come up, we will provide the security.
Yes.
It was the idea.
So you
That is why now the time is rising. Time is rising, lordship. I have to go to Tawang, and there is so many enemies.
see, you have sought for the security
Yes,
to the concerned SP.
yes,
They said agent when it comes, it will be provided.
yes.
You ask them, we don't provide security unless there is an imminent danger and the authorities are not providing security.
Lordship,
all response-
kindly,
See.
lordship. Page number annexure
So we cannot
6 maybe.
we cannot scuttle,
Yes, annexure 6
cannot
maybe.
stall the proceedings. All right.
Annexure 6
Okay,
maybe.
you appear. That's all. We're not saying anything. Will not comment more than this. Beyond this, will not comment anything.
Deeply applied.
Cooperate the investigation.
Definitely, I'm
if you are
cooperating, but,
innocent, nothing will happen to you. All right.
lordship, if anything's happened, that is the issue here, lordship.
See, you have already
After
said that
happening,
SP is ready to provide the security.
There is a law and order problem, lordship. There is a.
See, I'll tell you,
shooting incident.
the security is not provided on mere asking. There must be some threat perception.
Yeah,
All right.
no, no,
You will have to show that.
I have already
And
approached.
the authorities, if they are ready to provide you a security, you ask them.
Para number I have specifically mentioned in my para 9 of the years. Itanagar police station case is pending, lordship.
Which one?
Itanagar police station case in which there was a attack over the petitioner, saying that against, in connection with this complaint, case, saying that there is a prayer was made before this chief secretary, saying that there is a ST issue, non-APST matter, and PAC APST. This is the connected with the PAC APST matter.
Just
That is why.
will provide it. Huh?
Lordship,
It is next para. Having considered the submissions of Mr. T. Tapak, learned counsel by the petitioner, that the petitioner is apprehending a threat to his life while appearing before the investigating authority at Tawan, it is directed the concerned authorities to take appropriate steps for providing security in case any imminent threat to the life of the petitioner is found.
Lordship, in earlier occasion, the SB security had communicated that as per the intelligent info, there is no.
As per the in terms of the applicable rules and norms of providing security.
Yes.
Because it requires an intelligent, info.
Yes.
Just because that's why I said, just on
That
their
is the only
of the
problem.
person,
Yeah.
we have 134 crore population. It cannot be.
I'm not on that, Lordship.
Yes, I have seen so.